I want to welcome everybody to this demonstration. Did Jarvis attorneys score big today? But before we get started with this demonstration, salute to the chat, salute to all of my moderators, salute to the replay gang. Now, finally, things in the Jarvis butts. I'm going to label it the Jarvis butts case because he does have separate charges from Naziah Harris. So finally, things are starting to move along in the Jarvis butts cases. Now, drop a one if y'all think that the defense, which is Jarvis's attorneys. Drop a one if y'all think that Jarvis's attorneys was pretty much on point today. Drop a one. Drop a two if you think the prosecution was on point. Let's just jump straight into it, y'all. I ain't gonna hold y'all because let's get to the meat and potatoes. And as always, he's always wearing the mask. Now, from my understanding, months ago in his first court appearances, the conference calls, he was wearing the mask because he was on COVID watch. That was 5 months ago, I believe, 4, 5, 6 months ago when he was on COVID watch. And that's why he was wearing the mask. But is he still on COVID watch? I'll wait for my insiders to get back and let me know if Jarvis is still on COVID watch and what's exactly the reason why he's wearing this mask. Let's go, Rock Squad.
Yes, Judge. All right, good morning, everyone. We're calling cases 24-002, 25-000-218, and lastly 25-000-241. These are all in the matters of People versus Jarvis Butts. I apologize, I believe I missed one. There's also file 25-004-478. Can I have appearances? Let's start with the prosecutor.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And good morning, Your Honor. Matthew Makepeace also on behalf of the people, P82796.
Defense.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Jarvis Butts, together with co-counsel Ken Riggins and Lauren Butler.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Jarvis Butts.
Good morning, Your Honor. Lauren Butler, P88126, also from Neighborhood Defender Service on behalf of Mr. Butts.
Thank you. Mr. Butts is also joining us in court. Mr. Butts, your name, please.
Jarvis Butts.
All right, thank you. You can all have a seat. All right, attorneys, thank you for your patience this morning. We did have a relatively short chambers conversation about these cases this morning. And just to briefly summarize defense, you intend to raise an issue with regard to some outstanding discovery on the case ending in 218, which has the homicide charge. Is that accurate?
That's correct, Judge.
All right. It's also my understanding that there are 2 motions to quash filed today. The parties, the people submitted a written response to those motions to quash. I've had an opportunity to review them. The parties are ready to argue those motions today, correct?
We are, Your Honor.
Okay. Very good. All right. Well, let's start with the file Mr. Butts is here to be arraigned on, that being the file ending in 4478. How does he wish to proceed for arraignment purposes?
Yeah. Mr. Butts would waive the formal reading of the information. He stands mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. A plea of not guilty will be entered on his behalf. Counsel, was the examination held in that matter?
It was.
All right. We're going to get that transcript ordered. And with that, do you want to move right into the respective motions to quash, or did you want to address the discovery issue?
I think we can go ahead and do the motions, and then we can discuss the discovery at the end.
Okay, very good. All right, who's going to take the lead from the defense?
Your Honor.
Very good. Your motion.
Your Honor, thank you. So, Your Honor, I did file a motion to quash relating to case,
And let me just make a quick note, and I'm sure everybody has, seen it. He always has his head down, which, in my opinion, that lets me know that you're guilty. Even though it's not what you know, it's what can be proven in the court of law. But I just want to make a side note. In my opinion, whenever a defendant he always has his head down. Very seldom will he come up. But in my opinion, that's a form of guilt. I've said it and I'll say it again. An innocent man definitely ain't going to have their head down. It's like you're trying to hide something. What's up with the face mask? They say the eyes never lie. The eyes tell it all. The eyes is the mirror or the window to a person's soul. So I guess in him keeping the mask on and always having his head down, nobody can look into his eyes. But Jarvis, we pretty much already know that you're guilty. It's just proving that you're guilty. Because if you was innocent, I can't say you wouldn't have the mask on, but you definitely would be looking straight ahead. You're going to be looking like, I ain't do this. Can we hurry up and get this on? It's like he just sits there like a zombie. No motion at all. Just so in my opinion, and it's just my opinion, his body language, everything about him, in my opinion, leads to him being guilty. But guilty of what? Now, before I go any further, in my opinion, I think the defense did do a good job of fighting to get the inappropriate touching in the first and second degree thrown out. How many of y'all think? Now, I'm not saying that the defense won, because obviously the defense didn't win because the judge bonded it over. He's sending it to trial. But I do think that the defense, because the defense had me at one time, when the defense was proving the part about the penetration. And I'm going to let the defense and, of course, the prosecution and even the judge get into it and break it down. But at first, the defense did have me like, oh, snap. They didn't prove. Well, not they didn't prove, but the defense had me at first like maybe the witnesses wasn't able to prove that Jarvis actually penetrated. But it wasn't until the prosecution came along and, worded it, broke it down, and, really, really brought it home as far as there was some penetration. But in the beginning, I'm thinking, because I'm going by the defense. So in the beginning, I'm thinking that because the hand, he always made reference to the hand, and even the witness stated that he was touching her with his hand, but the witness never indicated the penetration. But that's enough of that. Let's appreciate this super sticker.
In 6232, for the sake of privacy, I won't mention the complaining witness's name, but there was a preliminary examination held in this matter. There was one witness called the complaining witness was the only witness called. She testified that at the time of the incident, she was 4 years old. At the time of the hearing, she was 13. So there had been a substantial passage of time. Your Honor, her testimony was she was home with Mr. Butts and Mr. Butts' girlfriend. At some point, the girlfriend left the bedroom. Mr. Butts was in the bedroom. She was on the couch. Mr. Butts summoned her to the bedroom, at which point she was ordered to take off her clothes. Her testimony was she took off all her clothes except her underwear. She took off her clothes. Then Mr. Butts touched her. I believe the order of touching her was he touched the top of her thigh, then he touched under her breast. And then she said he touched her where she peed. Okay. That was.
How many of y'all was like me? How many of y'all was like me as far as the defense? Drop a three. Drop a three if the defense had you second guessing it. And maybe like, damn, maybe they won't be able to get him with the inappropriate touching in the first degree. I always felt like definitely not in the first degree. Okay, Glory Girl says at first. And yes, this is a new hearing, the proceedings. This was done today. This was done today. Because like I said, at first I was like, man. Well, one thing I could say about the defense, at least he's not falling asleep. At least he's not falling asleep, y'all. Until the prosecutors brought up the ear statement. Right. I see you, Nene. Hell no, no second guessing here. You said you wasn't gone, Trisha. I didn't. I was disgusted by his lawyers, to be honest. I see you, Alicia. I'm confused because is this the same 4-year-old that was allegedly caught an STD from him that would not be from his finger? I don't believe this is the 4-year-old. The one that caught the STD, that was years ago, and that is what he caught the time for, the 8 or 10 years. But if I'm wrong, somebody correct me. But I don't believe this is the same 4-year-old. This is a different one. And he knows to sitting up there looking stupid. It's sad to me that there's women defending this man. Yes, yes. The defense had a hard time even telling that story. Tone says waste of emotion to quash from the defense. Side TV says, yeah, that's her. Okay, okay. Took my exact words. The next hearing is on September the 16th, where the state will have that information to present. Will the state have that information? And I'm upset when it comes to the state, because the state has been slipping as far as being on top of what they have to have presented. Okay, so it is the same one. Okay. Because see, it's so much with this case, and it's old victims, it's new victims. So that's why I always gotta ask you all to help me out, because when you think you got the case, here comes new victims, here comes new revelations.
The sole testimony of this witness. At the end of the proofs, the prosecution moved to bind over on an original count of criminal sexual conduct in the second degree and added a count of criminal sexual conduct in the first degree because of the statement of because of the statement of complaining witness. Your Honor, we believe that is an abuse of discretion. The only thing that we have on the record is she said she touched where she uses the restroom. And the only clarification we had was she said this is where she pees from.
Now I wanna build off of that because I do want to take this comment. Shank, it shouldn't matter if it's a touch or intercourse. The people better put this nasty man under the jail. When you wrong, you wrong. Jarvis is beyond guilty. Justice for Naziah. And that's so true. But we got to keep in mind that it's going to be a jury. We got to keep in mind it's going to be a jury. And if the defense had me going and a few others, if the defense had me going and a few others, I believe all it takes is for the defense to be able to convince one of the jurors. I'm just saying. I'm hoping that Miss Parker and her riders check with Miss Parker, and I would like to do another mock trial. I'm curious to see the prosecution and the state, as well as the jurors, when we done that mock trial. I want to see how well you all took in this information. So Ms. Parker and the riders, if y'all are down to doing another mock trial, I'm all for it. Just count me in.
Or she urines from, excuse me, those were her words. From that, we had the prosecution postulating that meant that there was some penetration, except there was no penetration mentioned. There was no penetration discussed. We know from case law, for a CSC 1 to happen, there has to be some form of penetration, even the slightest. Case law also tells us if she testified that he were to force her underwear inside of her, that would be sufficient for penetration. Yeah, we don't have any of that. We never have conversation, or we never have any testimony about her panties being pulled aside. We never have any testimony about her panties being forced in her. We never have any testimony about anyone penetrating her. Now, that is given the fact that she was 4 years old at the time this happened, granted. But at the time of the hearing, she was 13. Surely she could testify. I believe she was asked on direct that she remembered the events, and she said she remembered the events. None of that was testified. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of the CS1 is an abuse of discretion, and we believe that should be dismissed.
Thank you. And counsel, your respective motions, they're similar in nature in that you're arguing the issue of whether or not there's sufficient evidence on the issue of penetration on both your motions across, correct?
Correct.
Okay. Do you want to, why don't we have him argue his, on the second matter, and then we'll hear one response from the people, if you're okay with that.
That's fine.
Okay.
Okay, so this is then with regard to the case ending in 24101, and, sorry. Okay, this is Lauren Butler, P88126 again.
Thank you.
So first, to overview the facts from that case, I want.
Now let me just say this. Now, my man had me going. He did. Now she really had me going. And see, I don't want nobody to look at me different. It's just I look at everything pertaining to this case. I look at the good. I look at the bad. I look at the ugly. I look at Jarvis being a monster. Let's not get it twisted. I know for a fact that Jarvis is a monster. However, I'm a student all the way around the board. So I'm constantly learning. So I'm paying attention to the defense, because just because we may feel a certain way, what if the defense, like I said, what if the defense convinces one? What if the prosecution doesn't convince that one? All it takes is that one. So once again, the penetration. I know, y'all, I know. And I ain't even gonna keep going into it because I know y'all ready to throw all kind of stuff at me. Shank Rock, how dare you? So I'ma just leave it at that. But I was focusing on that penetration part, all right? And I'm gone, y'all. I ain't gonna put myself in quicksand. I ain't gonna take the rope and hang myself. So I'm gonna leave that alone.
To emphasize that this is only with regard to one of the two instances described. The complainant described two instances, but only one of them has been charged as first degree. And I am only arguing with regard to that and that particular charge. So at the preliminary exam for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration. And again, the case law is clear on this. In particular, the case I cited in my motion, People v. McNeese, well, that published, is particularly relevant because it highlights this distinction where it can be more than just, it uses very similar language to that use of the exam here with this emphasis on touching the vagina, rubbing the vagina. That's not enough for penetration. And there was even a specified testimony about under the underwear and over. And yet, even with that fact, the court still held that this was not penetration. And that's similar to what we have here, this description of some degree of touching of that area, but that alone is not penetration. It also relies on published case law, People v. Payne. Rubbing one hand, where it concludes that rubbing one hand over another vaginal area does not qualify as penetration. And I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So,
and see, that's what had me. Now, Tone, talk to me about what you mean by, oh, she did stand corrected. Help me out with this, Tone. See, for me, that, like I said, and it makes sense the way the defense is giving it to us. Penetration, because I did look up Michigan state law, and it does mention about penetration. There has to be penetration. So the way that the defense put it was like, yeah, there might have been some touching, and the touching is on the outside, but there was no penetration. But now, like I said, once the prosecution, hit it home, and once the judge shot a three-pointer on it, it all made sense. But, and this is just my opinion, whether there was penetration or not, he still inappropriately touched her. Okay, no, I was saying the defense cited a free. Okay. So, and like I said, y'all, I'm learning. I'm learning. So please, y'all, don't start throwing stuff at me. And in order for me to learn, I need to get all sides. I'm gonna be coming to the chat in a minute, y'all. Give me a few minutes. I will be coming to the chat. And I do have a special guest that's going to be joining me in a few minutes. Petersburg, VA has railroaded a young man, and his father will be joining us in a few more minutes as he tell us how Petersburg, Virginia, which is a common law state, but they railroaded his son. But let me get back, y'all.
while they're now arguing that that is possible, it's not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is now referenced in the motion was not used in the exam. So in conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration and bind over was not proper, specifically as to that charge.
Thank you. All right, who's going to take the lead from the people?
That's you, Judge.
All right, very good.
So I'll start with the first argument made by Mr. Riggins, the complaining witness there, referenced by initials PB. She testified specifically that he touched my private part where I use the bathroom with. When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? She states he rubs my private part with his hands. I then clarified, is this on the top part of that? And she interjected, said the bottom. And I said, would that be where the pee comes out? She says, I clarified, is that a yes? So in summary, she testifies she's rubbing the bottom part of her private part where the pee comes out. Your Honor, in a motion to quash the highest deference to the reviewing magistrate in this case, it requires an abuse of discretion, which is most deference to the district court. Penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of that labia majora is sufficient to establish penetration or criminal sexual conduct in the first degree. Here, the complaining witness testified that the defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, thereby penetration. The examining magistrate also found that, and said in her ruling, that for a woman to urinate, it's not on the outside of her labia. That's an internal. That would be beyond that. And so she found that it was a question of fact. I don't believe that there's any abuse of discretion by that. I believe that there's satisfactory testimony, at least to a probable cause standard, for that count. And do you want me to go on to the next one?
Please.
Okay.
Let me jump to the chat, y'all. Let me see what the chat got going on before I let her continue. Appreciate the super sticker, Red Jewel. Appreciate the super sticker. And if you would like us reach our goal of 15 super stickers or super chats, you could click on the $ symbol. Appreciate it. Let's see what the chat is saying. 4 years old. She's a toddler to me. She probably was still pissing in the bed. Now tell me, how sick was this? I feel you. That's sick. The fact he even has the nerve to have a lawyer, public defender, knowing he's done all this ish, they say he's done, is beyond me. Them some nervous blinks to me. Exactly, Charlotte, because it's no excuse possible. So the way he did it don't matter. It is the way. But the way she explained it, how did she make this up? Yeah, laws different state to state. How you trying to prove some innocence knowing you guilty? Sick. Dedicated. He won't even look up. Just disgusting what he did to those girls. His cellmates are watching closely. Justice for Nazar. Can I get everybody to throw up some purple and pink hearts? And also make sure we hashtagging justice for Nazar Harris. He's having a panic attack. I can see how hard he's breathing and blinking. OMG. Then why did you do it? He can't hold his head up because he's shamed and knows exactly what they're saying is true. I do have my special guest backstage. You all, let me grab these super stickers and super chats. Appreciate the super sticker, Red Jewel. Appreciate the super chat, Tanya. Thank you for your hard work, Shank Rock. I'm going to run just a little bit more of this, and then I'm going to bring up my special guest. Matter of fact, I need to bring up my special guest now because he's at work. So let me bring the good brother up and let him tell us a little something about how Petersburg VA railroaded him and his son's death. Can you hear me, good brother?
I hear you, brother. Salute.
Salute. How you doing, brother Jamal?
I'm good, man. Thanks for having me on, Shank.
Yes, sir. I know we on a tight time schedule. Walk us through what is going on with Petersburg, Virginia, in your son's case.
I'm just going to do a real brief. So back in 2018, my son was brutally murdered, right? Yeah, he had been tortured. He was beaten, man. They found him naked, bound. He was shot 6 times, left on a porch. Right from the beginning, bruh. Family, right from the beginning, you can tell it was something going on with the investigation. The police did not search the apartment he shared with his girlfriend. His Facebook page was deactivated 48 hours after his murder. I could say that.
Yes. Say red rum. Say red rum.
Okay, red rum. Yeah. So his Facebook page was deactivated 48 hours after the red rum. The police did not really look into that at all. No warrants. They didn't try to get into the page. I mean, that could have been an easy, found the IP address or something. About a month after the red rum, right on a news broadcast, the police lied about the crime scene, lied about how his body was found. From that point, the case just went super cold. I mean, it's been several, in 7 years, there have been 4 different detectives on the case. At the time of the red rum, the feds were investigating Petersburg. They never asked the feds for any help to get into the cell phone, to track the cell phone. I mean, just a real sloppy investigation. Last year, I had 2 Petersburg police officers tell me that my son's red rum was behind him turning in a package of narcotics that he received in the mail. He turned them into the police department. The package disappeared. So it's kind of like, it appears that they just covering this whole thing up to try to save face, right? They investigated this red rum. It's been so sloppy. I'm kind of like on a timetable, so I'm just trying to breeze through the basics of it. But I go into more details, like on my TikTok page, Justice for Tahj. I go into more details of exactly a lot of the things that went on in this case that are just questionable. A lot of lies. I mean, they've lied about the crime scene. They've lied about his last known whereabouts. The Facebook page was deactivated 48 hours. That may seem simple. It's simple for one of us to deactivate our Facebook page, but for somebody to be, red rummed, it's a little more difficult just to deactivate a Facebook page.
Right.
But it is easy for the police to have access to it. So for them not to even follow up on that is very suspicious. The multiple lies, they don't tell the family anything. And just recently, I think maybe last year, they've involved the federal, the FBI's violent crime unit is assisting with the case. But what they're trying to do is make an arrest without having to address the motive, right? They don't want to talk about why it happened. So that's just like a little brief breakdown on how this case has been going. I've had multiple people tell me about the corruption in the Petersburg Police Department, and my son's case is just funny because of what these like. This didn't come from the streets. This came from a police officer letting me know, like, listen, this is why this happened. Drugs were delivered to his house by mistake. He turned them in. The drugs disappeared. At the same time, you had a corrupt cop who was mishandling evidence. right? I mean, this is proven. This is in the news. Officer by the name of Roosevelt Harris, he was putting evidence in the ceiling, the dumpster, just mishandling evidence. They allowed this man to just walk away. This man just retired. So, you know, like I said, you know, I'm just giving a little brief breakdown of certain things that happened. And it's, you know, we still haven't received any justice in this case. Like I said, they don't work with the family. They don't tell us anything. They don't want to tell us. They definitely won't talk about the motive. No, they're not going to say why this happened at all. Like, I find that very suspicious. Like, where do they do that at? Most times, you know, the police don't have a problem telling you, look, all right, let's say it this way. We know when it comes down to a black male, they have no problem telling you this guy was a gang member. This guy was a felon. They would have, if any of that was true, they would have said his whole criminal history. But in 7 years, you'd have known everything about him. But in this case, they've been so quiet. You look at this case, you won't hear them whisper about his criminal history because he had none. They won't say he was attached to any gangs because he wasn't. So why would something like this happen to a young man like that? 22 years old, he had a 2-year-old son when this happened, right? He was into his music, playing basketball. He had just got a job. So, you know, he wasn't into the streets like that. Maybe, you know, hung out, smoked a little bit with his friends, but he like that's a consistent. And definitely, like, I have audio recordings of the police talking about he wasn't tied to a chair, talking about this was a mistake. That's what they're trying to call this. This was a mistake. But in 7 years, these people have never come out and said, hey, man, this was a mistake. This was a tragedy. This was an innocent victim. They, you know, I expected that. I expect you to come out the same way you would have came out and said he was a gang member. I expect you to come out and say, hey, you know, this was an innocent young man. You know, where is the urgency in solving this case? This wasn't not to downplay anybody's death, but yo, this young man suffered. They burnt this young man with lighters. They tortured this young man. You know what I mean? So they've had help from the news. I've got into it with CBS 6 Richmond behind the way they have handled my son's case in the news. So it's been a fight. It's been an uphill battle. So I appreciate you having me on, man, and helping me try to bring some awareness to this case.
No doubt. May I ask you a few questions? Just a few.
Absolutely. Absolutely.
Okay. When is the last time that you came in contact? When is the last time has the police department been in contact with you?
So last July, I had a meeting with the supervision of the Petersburg Police Department. So it was the captain, lieutenant, sergeant, and the detective investigating my son's murder. Since that time, it's been a few text messages. They really don't like to deal with me because you don't get to tell me what to say, right? You want to keep everything hush hush. Or, you know, we don't want to talk about this. First of all, you're really not talking about nothing. You're really not telling me nothing. You know what I mean? Everything I'm learning on my own. So you don't get to tell me. You've been hush hush for too long. Right now, my most contact with law enforcement is the FBI agent who from the violent crimes unit. Like, they flew out to Georgia to meet with me. And those are the ones who actually contact me and let me know now where they are with the case. They're a little bit more open with what they talking about. But I think the last time he hit me was maybe last week, because he had met with some people that was in jail. So, but as far as Petersburg Police Department, I don't really deal with them too much. They don't really deal with me either.
Right. Now, VA is a Commonwealth state. And these are black officers that is involved, correct?
Correct.
How does that make you feel? I mean,
first let me say this. I'm super pro-black, right? You know what I mean?
Right.
Like, you know what I mean? I'm for us like that.
Yeah, speak your mind, bro. Speak your mind.
So that's disgusting to me. Like that, and I'm so pro-black that it's hard to bash us at the same time. You know what I mean? Like, I don't like to bash us. I don't like to throw up the fact that Yo,
Right.
these people black.
Right.
But but I know we have us, and then we have the same way that these, I don't want to say that, I don't want to use that C word, but the same way they try to look at the hood and say they're the problem. I also know we have another problem. We had this problem for a long time that we don't address. We're not allowed to address because these are supposed to be the pillars of our community. These are the ones that, get held up high, but they're the ones that do a lot of damage. And that's who these guys are, right? These are your Kappas, right? These are your fraternity brothers and sisters. These is your HBCU graduates. This is who these police are. When I, of course, I'm gonna do my due diligence. So I know some of them belong to fraternities. I know some of them belong to sororities. I've reached out to the NAACP Petersburg, only to be told, oh well, to the president of the NAACP Petersburg's chapter, for her to only tell me, well, that's not in my will. I'm gonna send it over to my legal. So yeah, it's really sad when you looking at your own, people that look like you. But I also know, they're gonna protect their own interests.
And I've done a demonstration yesterday, a demonstration as far as Black Americans, we taking accountability. When are we going to stop pointing the blame outwards and see when it comes to Black Americans, the hood, the brothers and the sisters that's in the hood, they get the most blame, but it's just not the brothers and the sisters in the hood, you know what I mean, that has to take some of this accountability as well. Now, you spoke about your son, never had a criminal record, never been in trouble with the law at all. And see, I cover these cases all the time. Why is it that the good ones, why does the good ones in our communities, why do the good ones always become victims? Now, I dropped the brother's TikTok link, and I need everybody to follow him on TikTok. And if it's anybody that's watching in the chat, if it's anybody that's on the replay game that can give the brother some kind of assistance with his fight for justice for his son, please reach out to him. I will be bringing him back. I'm going to be bringing the brother back so we can take a deep dive into the corruption that's going on down there in Petersburg, Virginia. Brother, is there anything else that you would like to discuss with us before you get out of here?
Yeah, I just would like to say, like you just said, man, if anybody could lend any assistance, I have a few people that have reached out, but one of the biggest things is bringing awareness. Man, if you could share it, on your social media. And I just want to share this. One thing about me, if you're watching, I come with receipts. So anything you just heard me say, best believe I can back it up. I've been doing this for 7 years. I investigated my son's murder, and I investigated the investigation into my son's murder. I come with recordings, text messages, emails. So this is not one of them cases where a brother is getting on here and saying they doing this, they're doing that, and then you're gonna come and find out later on that I was just blowing smoke. You know what I mean? So if you can share it on your social media, talk about it in your coffee shops, let people know, hey man, this is going on with this guy, his son. I would appreciate it.
Before I let you go, because why it's on my mind, they mentioned something about the cheer.
Right. Yes. So that's what I meant about the crime scene. So about a month after my son was unalived, they came out and said he was tied to a chair using some type of construction tape. This is what the lieutenant at the time, he's the deputy chief now. This is what he came out and said. That was straight false. He was never, and a lot of people take that with minimal concern. Well, whether he was tied to the chair or not. Nah, it's serious because he lied about the crime scene. He changed the whole crime scene And the fact of the matter is, it wasn't a mistake because it wasn't in the police report, right? This guy was a veteran. He knew all he was doing. All he supposed to did was read from the police report, and that was it. He created a whole nother crime scene because the whole thing was to make it look like something it wasn't. It was already brutal, right? When you look at it, you go, man, what was he into, right? So when you add, he was tied to a chair, and that's how the news played it. You know what I mean? So it makes people go like this. Do I want, like, all right, you got a podcast. When you look at that case, if you didn't, if you didn't hear it from me, you would go, that's a sad case, but yeah, I ain't really gonna touch that because the young brother must have. You understand what I'm saying? And for years, that's what was able to keep the case from being talked about a lot. And it took me I knew it wasn't true from the beginning because I had spoke to the witness across the street myself. So I knew what the man told me about the chair. No news prior to that police officer saying that, nothing was brought up about a chair. I have the police on recording saying that chair had nothing to do with that case, but it was to make an image, to make it look like something that it wasn't. And that kept people from talking. I couldn't really come out and say nothing about it at the time because it was the police word and the media word against mine. But now that I have that recording, I'm able to expose that and let people know, nah, that chair had nothing to do with this case. That man lied. You know what I mean? So yeah, that was a big part of it because that right there shows that they straight up was lying.
Wow. We got our work cut out. As always, Rock Squad and everybody that's tuning in, if you can be of any assistance to the brother, reach out to him on TikTok. For those that's catching this on the replay, gang, I will be dropping his link in the comment section. And everybody that's in the chat, I done dropped his link to TikTok because then you'll be able to see all of the receipts. You'll be able to see so much more. And I mean, when I was watching the videos and when I was tapping into it, I was like, God damn, I don't believe this. I don't believe this. But we definitely got to get you back.
Absolutely.
So just keep the faith, keep praying, and I'll get back in touch with you. If not tonight, I definitely will hit you up tomorrow, and then that way we can schedule another day and time for you to come on, and then we can, go deep because I want to spend some time with you up here, and I want to, if I can, I want to play some of the videos and all of the other audios and things of that nature, if that's possible.
I appreciate it.
All right.
Yes, sir.
Appreciate you, good brother. And I will be getting at you. Probably give me tomorrow, and I'll hit you up tomorrow.
I appreciate it, Gary. All right, Shaq. Salute, brother.
All right, salute, good brother. As y'all can see, the work never stops. It never stops. It never stops. Make sure we are following the brother. Let me throw this up here. Jamar, check out Rhonda Young. She is in VA. I know she will help you. Let me send him a quick message real quick. Give me a minute, y'all. And then we're going to get back into Jarvis Butts. What's that? Rhonda. And if anybody on the replay gang have any information, please drop it in the comment section for me. All right. Appreciate you, caller. Let's tap back in a little bit more on the prosecution, y'all.
The second case, extremely similar. This one is specifically, this complaining witness starts off by saying, how, how somebody would play with you in your sleep, like you would feel them in your ear, like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up and I was crying. I stated, all right, when you wake up to feeling something? She said, yes. I asked, where do you feel something at? She says, at my vagina. And I said, what do you feel at your vagina? Did I feel like somebody's playing with me? Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, what part of him is touching it? How touching you? She said, he's using his hands. She later confronted the defendant about it. He's asked her why I was acting so weird towards him. She said, you don't remember what you did to me? The defendant, looked me dead in the face and said, I don't remember doing that, but if I did do it, then I'm sorry. Again, the reviewing standard is abuse of discretion. And here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against a vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hands at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge. The vaginal opening is beyond beyond or inside both the labia majora and the labia minora. And so because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so by stating that she felt the defendant's hands at her vagina playing with her, she testified to penetration. And I believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is, again, probable cause standard is the lowest standard and abuse of discretion is the highest deference to the examining magistrate. And I believe that they both create questions of fact.
And see, that's what helped me look at the penetration for what it is. Because when you think of penetration, naturally you thinking of, penetration, the male instrument, penetration going in the female instrument. But she helped me understand exactly where the penetration apart. Yes, this is new. This is Jarvis in court today. So this is new. For everybody that's just pulling up, this is new. This was today.
Thank you. Your defense, wish to respond?
Your Honor, in all seriousness, we're giving far more biology of the human anatomy than we've ever put on the record at the preliminary examination. All we had at the preliminary examination they were touched at the area. We have young ladies who, although at the time this happened, may have been too young to describe the actual part. At the time of the preliminary examination, surely they could have said, he touched me on the inside.
Now, I'm definitely going to be careful with my choice of words, but see, I'm that for me, y'all. And don't start throwing stuff at me yet. Just let me get out what I'm going to say. By them being at that age, did they know? Could she have possibly known? I mean, and I'm not saying that a 4-year-old don't know. I'm just raising a question, y'all. I'm raising a question. I know. I'm going to just kill it. Let me kill it. Because I can see y'all ready to come for me. Let me just kill it.
He forced my panties aside. He touched me on the inside. And in either case, was that testimony ascertained, that testimony was given, that question was asked by either people. So here, all we have is hyperbole. This is what the complaining witnesses must have meant when they said that. You know, I think that is a far reach, and I think surely that is an abuse of discretion to just simply say they must have meant there was internal penetration. That is an element the prosecution has to prove in each and every case when they charge a CSD in the first degree. In neither case was that proven, was that ascertained. We just have speculation, and to put those charges in front of a jury would simply be wrong, Your Honor. So we're asking you to grant both motions to quash.
And that's what I was leading to, Nina. Or a kid can't really explain that. Is it? I mean, what are y'all thoughts? I know y'all thoughts, but that's where I'm at. Like, could a 4-year-old child explain that? Salute, Raw. She knew it wasn't right. I'll take that. Okay, Sean. He looks like the coward he is, shaking my head. I see you, Michelle. All scientifically. These defense attorneys. I see you, Spicy. Yeah. A lot of 4-year-old are innocent, but they know what's going on and right from wrong. That's facts. I'll take that. No, a child can't explain that. There is no way I could be an attorney and take any cases like this for real. I shared an abuse I saw when I was young, and the first question that was asked to me by an adult was there penetration? I was 14 and had no idea. Okay. And that's where I'm at as far as like, because we got to keep in mind, you know, she's a 4-year-old. You know, would she know all of that? I see you, Jordy. I don't care what they talking about. The fact Jarvis had a 4-year stripped down to her underwear is sick and should be treated just as great. Sorry, not sorry. Now, I feel you, Paris. I feel you. This was Jarvis' strategy. How many of y'all think that this was his strategy? What are y'all thoughts? But he had no business down there doing anything. And that's facts. That's facts right there. Whether there were penetration or not, whether the 4-year-old could remember or not, Jarvis Butts had no business inappropriately touching her, period. Touching them, period. That's facts. It depends on parenting style. Whether she was penetrated or not, he inappropriately touched her. I don't understand. And that's true. That's true. The household dynamic makes me think they knew what, you know, was really early. I think they did too. I think they knew. My response was, I don't know. And they don't point is their children. Yes, they can. I feel you, Freshie. A 4-year-old knows they might not know at all, but they know where the areas are that are not to be touched. I agree with y'all. Yes, my daughter talks clear to be a 2-year-old. She articulated what happened to her well. I know I couldn't defend him. How many of y'all think y'all could defend him? Drop a 5. Drop a 5 if you think you could defend Jarvis. Do you think you could defend Jarvis, Tone? Salute, Raw. They wouldn't know the concept of intercourse, but know not to be touched inappropriately. Now their story is irrelevant. I could defend Jarvis. Why is the mask still on? Then again, I couldn't defend Jarvis. Let me take that back. I ain't setting myself up. I couldn't defend Jarvis.
Judge, I would just reiterate what he is already saying. I think in my case in particular, there's this emphasis on the word at. There's just it's not realistic to say that that's what at means. This comparison between at and over is really not what plain meaning tells us about the word at. At is very different from inside, all of what Mr. Wiggins really just emphasized. So again, I would object that this should be dismissed today.
All right, thank you. All right, well, on a motion to quash, and there's 2 motions to quash that have been filed by defense. The court has to review the record for an abuse of discretion, which has already been pointed out. The abuse of discretion standard is a high burden. And defense here, through their written and oral arguments today, have challenged the sufficiency of the evidence presented on the bind over of the respective counts of criminal sexual conduct in the first degree regarding the issue of penetration. So the court has had an opportunity to listen to the respective arguments from the attorneys here today. I've also had an opportunity to review the lower court record and namely the transcripts. And of course, the prosecution at the preliminary examination has the burden to show competent evidence that probable cause exists on each of the elements of the charge of offenses. So here, looking at pertinent portions of the transcript, and I'll start with the case where PB is the alleged complainant. There's a few pertinent portions of that examination transcript, starting on page 58. And it notes line 20, her answer to a question, he touched my private part where I used the bathroom. Question, okay, and when you use the bathroom, what comes out? Answer, urine. Question, urine, okay, tell me about what part of him touches you there. Answer, his hand. Question on the following page, okay, what does his hand do when he touches you there? Answer, he rubs my private part with his hands. Question, okay, was this, so when he's rubbing your private part with his hands, is this on the top part? Answer, the bottom. Question, the bottom part, okay? Answer, yes. Question, okay, and is that would be where the pee comes out? Answer, yes. With regard to the file where the alleged complainant is AD, I'm directing the attorney's attention to the pertinent portion of the testimony on this issue of penetration, page 83, line 14. This would be multiple paragraphs into her respective answer, reading, and you know how you like how somebody would play with you in your sleep, like you would feel them. And I think the pertinent part of this answer that's relevant to this determination is the next three words. And again, it's like you would feel them, quote, in your ear, like this or something. He was doing that to my vagina when I woke up and I was crying. Moving to the next page, page 84. Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer, yes. Moving to page 85, line 8, question, all right, and when you wake up, you kind of wake up to feeling something. Answer, yes. And where do you feel something at? Answer, my vagina. Question, what is it that you feel at your vagina? Answer, I feel like somebody playing with me. Like, I don't know, like somebody like trying to touch you, but trying not to wake you up while you're touching you. Question, okay, and do you know what part of him he is using to touch you? Answer, he's using his hands. So sexual penetration is defined, and that's defined under 75052-0AR as sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of another person's body, but emission of semen is not required. And here, based upon my review of the lower court's record and testimony utilized in making the bind over decision, I think based upon the testimony that I just read in the record verbatim, the examining judge did not use her discretion in binding over on respective counts of criminal sexual conduct in the personal group. I think there was sufficient evidence presented on each of the elements, and specifically the elements of penetration in both files, to uphold the bind over, and attorneys are going to respectfully deny the motion to quash. All right. So attorneys,
Judge.
we have a couple of other issues to discuss. In defense, would you like to get into the discovery issue that was noted earlier?
I understand that. So one of the largest pieces of evidence is the CSLI that was used at the preliminary examination, which the prosecutor posits puts Mr. Butts at the scene of where certain pieces of evidence were located.
And so we're clear, counsel, you are moving into the file ending in 218. Correct?
Yes.
Okay, thank you.
Apologize. Thank you.
That's okay.
Back on February the 6th, Mr. Riggins reached out to the people and alerted them that our expert to review it, we needed the Celebrate UFED, basically the underlying data that is pulled, not the report that is generated from Celebrate.
What was the date that was put on notice?
February 6th.
February 6th. Okay, so just about 6 months ago.
Correct.
Okay.
And then we received a response back on the 14th from people saying that they would work on it and get back to us. We received another response on the 28th that they were looking for the files, essentially discussing that it's a huge amount of data that has to be transferred. And then we followed up, it was sometime later. And the next response I have is from May 28th, that there would be follow-up with the right person at DPD. They would get back to us. So we've been in communication with the people about this for this entire time. There's no surprise that we've been asking for it. And the response has generally been either that the DPD has it and they're working on transferring it, or that it's taking a really long time to do because the data is so great. They have to basically go through they would take it from a hard drive onto another thing that can be transferred, put it on ours, and then they can send it to us. And as of this morning, we still don't have it. We are less than 2 months out now from trial, and given this is a huge amount of data, we have to have our expert look at it. We are very concerned that we don't have it yet.
Yeah, so the judge denied the defense motion. The judge did deny the defense motion. Yeah, so in that aspect, the prosecution won, but now the defense is pleading that they still don't have the, and Tone can help me out, but the prosecution has failed to deliver to the defense necessary paperwork that the defense had ample amount of time to get. So what's really good with the prosecution? And in my opinion, Tone and everybody else can help me out. This can, okay, Tone, this can hurt the prosecution down the line if the defense has to file for an appeal. Let me grab some comments, y'all. Question. So do we know if she was shown a picture or example of where his hands were going? I believe that would have helped. I don't know if they would have allowed that, but it's just a thought. I don't believe that they did. I don't believe that they showed the victim, the witness, any picture. Spicy says, the body language in that room is so tense. I hope they stream the trial. Me too. Let me grab some more comments, y'all. Salute, Tower. This is a case that no one gonna forget. Yeah. Nene says, yes, it can, Shank. Okay. My defense attorneys don't look at, most defense attorneys don't look at just the charges. They look at if they would have the possibly to get the defendant off. Correct. And they looking for all kind of loopholes. I know I would. I'm playing chess. I'm thinking 3 steps ahead, but I'm definitely thinking 2 steps ahead. I'm thinking of an appeal, because I'm like, okay, if they burn us at trial, we got an appeal coming. So I'm with you. Yes, I see how he was gagging. As parents, we need to start telling our babies about good touching and bad touching. My mom schooled me, and I schooled mine and others around me. We got to be parents and stop trying to be our kids' friends. That's facts. That's facts right there. You ain't never lied. That's facts. Shank, they might let the defense get they won in. I don't know, because this sick puppy is going down. I feel you. Salute, Marty. It's just the phone information. Defense will have it on Wednesday. And I believe, and Marty can correct me wrong, I believe we have one spot left in this year's Rock Squad 3rd annual meet and greet. If you are interested in attending the Rock Squad 3rd annual meet and greet, please see my moderator, Marty. It's been too long. It's been months. What's really going on? I'm going to need that black lawyer to go to bed early because he's always dozing off. But he wasn't dozing off on this one. That was the first thing I noticed. He wasn't dozing off on this one. The defense trying to dismiss what penetration is already showing their cards. Yeah. Jarvis needs to be ordered to take that mask off and sit up straight. I agree. I would like to see him with the mask off. It could prosecution stale tactic to hold them up, but it could backfire and cause them to push the trial date. That's true. That's true. When interviewing kids, they usually use a doll, and anatomically correct doll is what they will use so that the kid can demonstrate what happened. Just joining. Appreciate you, KN Ram. Appreciate you. Y'all, so for this, our family members allowed, it looks empty. I ain't see too many people in the courtroom. I didn't. Can't wait till the get Harris women into custody. It's funny to me, he's wearing the mask like no one will be able to recognize him. Doesn't he realize this case is worldwide? That's facts. That's facts. That's facts, y'all. I'm not going to hold y'all that much longer, and then we're going to get out of here.
Understood. So we do have trials set in that file. I've got it set for October 6th, so we're just north of 2 months by my math. So Mr. Makepeace, did you wish to respond from the people's perspective? Why has this taken so long when it was put on your notice 6 months ago?
Yes, Judge. No, and I'm not disputing the dates or the emails that Ms. Quick referenced and the responses. There was a period of time where we had kind of, because it is an unusual request for the underlying file. They do, for the record, are in receipt of the cell phone forensic extraction reports that are generated, which are files that are usually turned over. Those are UFDR files. This is the underlying file that comes with that or is generated and then put into a report. They have requested that on the dates and times. There was a period of time where I had to communicate with the OIC as well as the cell phone expert at DPD to figure out exactly what they were asking for. That did take some time, and then there was a period of time where I requested from the defense a hard drive that they provided to us for these to be uploaded onto. That hard drive, and I don't have the exact date in front of me, was turned over by Mr. Riggins to me. I transported that hard drive to the Detroit Police Department and provided that to the officer in charge of the case, as well as with the understanding that she and the cell phone expert would get together and get this uploaded. That's where I think the biggest delay comes from, is that there was a little bit of a miscommunication to them, between them, on our side of it, which is that one said it was done, one said that the other person did it, and nobody actually ended up doing it. When I went back to pick it up, it wasn't done. At that time, I brought the hard drive back to DPD and said, this needs to be done as quickly as possible. That was within the last month or so.
But y'all got to be on top of that. It ain't no excuse. And we already know how the DPD get down. Prosecution, y'all got to get on top of this. Come on, prosecution. Shank Rock, look at that officer, the black female with the bun. You look alike Miss Parker. Jordy, I see that too. Saw him turning red when reading his notes. Yeah, they did in 7 months. They don't have discovery bullish. They could have asked for a mistrial. Marty says, contact me. The judge is disgusted, LOL, how he was sagging, ready, that mess. Tone says they had too much time. They had enough time, didn't they, Tone? Lady Leo says, King, where you at, Ninja? Salute, Miss Jackson. The officer lady looks just like Miss Parker. Look, she be getting right, Patricia. I feel you, Patricia. That just needs to stand 10 toes down because he probably has children of his own. They had more than enough time to have this together. That's facts. I see you, Juanita. Salute, Juanita. Prosecution, I'm going to need y'all to get it together. Because one thing I can say about the defense, the defense is putting up a fight. They is. And they waiting. They waiting for that opportunity to land a haymaker. So don't get it twisted. They waiting. That lady cop looking at them with the side eye too. She knows. I see you, chick. They typically have 15 days to produce discovery. They on BS. Jarvis cannot decide himself with that mask on Detroit, and everyone that's covered and following this case knows that's him. I was so disgusted. I feel you, Tannis. I feel you. Tannis says, for real. I feel like he's hiding his face. He doesn't want potential victims to see him and come forward. Remember, True Witness didn't know his real name. She recognized his voice. He has so many victims. You right, blessings on blessings. You so right. You so right. I believe the defense asked for a task that they knew would cause a delay. You right, Levit. You right. Marty says mouth deuce. One, to stay in the house is $250, includes 3 meals a day, the Airbnb, etc. The defense got all they ducks in a row. They do, Jasmine, and they just waiting. They waiting for that golden opportunity. He needs to take that damn mask off, sicko. I didn't either. I wonder why. Blessings. Shank, did you see? I told you that when they're interviewing, they use an atom anonymically. Yeah, I seen it. I read it out, Freshie. I read your comment out, Freshie. Appreciate that comment, Freshie. Prosecutor is the perfect example of house messed up. Let me backtrack. Prosecutor is the perfect example of how messed up DPD and the state as a whole is. And that's what me as a content creator and all of the other content creators was saying when we was coming for Kim Worthy. They gotta have they ish together. Appreciate that comment, lovely. The state of Michigan gotta have they ish together. Y'all listen to this part. He was crying, but wasn't crying while he was hurting the babies. What are the dates for the meet and greet, Marty? At this point, just hire you and Miss Parker. Pretty much. Pretty much. Yes, they are. All right, let's tap back in, y'all, and then we're going to get out of here, y'all.
The actual process for them to upload these or get the files onto the hard drive is to take it from a Blu-ray disc or a DVD onto a computer and then onto the hard drive itself. That does take some time, given that there are, I think, 15 or so phone dumps that they've requested these files for, and the amount of information is large. As of this morning, I spoke with the cell phone expert who is in the process of doing this. He states that it will be done middle of this week, Wednesday. And at which point I will myself go to DPD, gather the hard drive, and provide it directly to Mr. Reagans or Ms. Quick or Ms. Butler.
Okay, so you believe you will have it to them by the 6th?
Yes.
Okay, which is exactly 2 months out from our trial date. All right, why don't we schedule an additional pretrial date for all files? Bring it in to hash out any potential trial issues and things of that nature. Also noting the people did file a notice of other acts. Which files which files did you file?
Judge, I filed that on all of the cases except for the newest one, because that one wasn't in the system yet. So yes, there should have been 4 filed as of last week.
Okay.
And we do intend to file an objection.
Yes, Your Honor.
Very good. So why don't we schedule a date to hear that? Are you anticipating filing a notice on the case Mr. Fox was arraigned on today?
Yes.
Yes.
Okay. Defense, how much time do you want to respond?
2 weeks.
Okay.
I apologize, Mr. Riggins is out of the office for one of those next 2 weeks, so if we get 3.
Want to come back on Friday, September 5th?
Judge, I'm off that day. Back the next Monday though.
Is this something, Ms. Ripley, that you would be able to handle in Mr. McPeace's absence? If not, I can find another date.
It is, Judge, but I'm going to be in a 2-defendant homicide trial that starts on the 2nd. And it's in Judge Cusick, so I anticipate it going on Friday.
Okay, understood. What if we come back on Friday, September 12th, mid-morning?
If we could come after my exam, that would be good for me.
The 12th is not a good day.
The 12th is not a good day.
I could do the 11th. That was
Ms.
good.
Ripley on the 11th?
I'm gonna be in that 2-defendant homicide. It's at the 15th or the 16th. I know that's cutting close, it's starting to cut close, but
I think we could do the
How about
15th.
Tuesday, the 16th? Does that work for everyone's calendars?
Seems to work. Yep, that works.
Okay, we'll come back Tuesday, September 16th, to listen to argument on both the files. Let's set that hearing at 10 a.m. All right, were there any additional issues that needed to be talked about or addressed from the people's perspective for today?
Judge, no additional issues. As I would in any case, I would just place on the record an invitation for defense counsel to come to our office to go through both paper and digital files to make sure that there are no other surprises. Just place it on the record. Ms. Quick, Mr. Riggins can communicate with me to set that up.
Absolutely. And as noted in chambers, when we set our October trial date, it was far off in the future. It was far off in the future with the, of course, the intent that all parties would make sure that they're doing everything possible to make sure that this case or case is trial ready for October the 6th. So, at this point, we've got our trial date, October 6th, and we'll see you for pretrial date, again, Tuesday, September 6th at 10. Were there additional issues that defense needed to address for today's record?
I don't believe so, Your Honor.
Very good. I thank you all for your time and your patience today.
Let me check what my comment section is saying. Let me see what y'all talking down here. Juanita says, if the prosecution apply pressure, they can execute this case. Also look into Annette and Shannon to see the part they play in this whole case. I just don't like it, y'all. I just, as much as we know that Jarvis is guilty of inappropriately touching Naziah and these other children, as much as we believe that Jarvis had some kind of acknowledgement of Naziah's death, the case to me is they need to tighten up. That's all I'm gonna say, y'all. They need to tighten up. Yes, because we need more people to volunteer to force these people to get to moving on these cases. That's very close to trial. Prosecution got to get together ASAP. We all need to call up there. Make them phone calls, y'all. Make them phone calls. And yes, that is Naziah's birthday, September the 16th. That is Naziah's birthday. I'm a rider, and we be calling in all. Once again, shout out to Miss Parker and her riders. And shout out to my rock squad as well. Yeah, that mask can get ripped with little effort, Deputy. I bet you won't. I see you, Jordy. I'm learning how to use the chat. Yep, that's our birthday. We got 427 watching. Let's get my likes up, y'all. Hit that like button. And if you would like to help us reach my goal of 15 super stickers and super chats, we are only 8 super stickers and super chats away from reaching our goal. Just click on the $ symbol and purchase a super sticker or a super chat. Karen says, sorry, you and your family are going through this, Jamari. That judge at one time was a good, you know what, lawyer. Wait, now her birthday. Yes, Lady Leo, her birthday. The bailiff looks like she wants to throw up on him. You'll get it. That demonic trio, Annette, Shannon, and Marquita. Lady Leo, yes, her birthday. How disrespectful is that? Virgo, baby. We should boycott that date for court riders. I think so. You good, Tannis? You good? Salute, Miss D. Who keep cutting this man hair? I don't know. I think he cutting it on his own. He must be cutting it on his own, Lovey. Who we need to call? Facts. So when will Kim Worthy join in? I'm confused. I have no idea. I'll check in with Miss Parker and find out from Miss Parker when do Kim come in. I see you, Sean. Pocahontas says, listen, look at this. Pocahontas, y'all keep changing y'all names. Y'all still got the same profile. Y'all know it throws me off. There we go for them to have the date on the Zaya birthday. Yes, it is. There you go. There go my troublemakers. Y'all have the famous. I thought something was wrong. I said, why ain't nobody throwing up the funky ass and the tacos? But y'all have Tyra to thank for the infamous picture of Jarvis' stable of women. I want y'all to thank Tower Scales for the infamous picture. I ain't showed it in a couple demonstrations. I said, God damn, where the troublemakers at? Troublemakers ain't troublemakers no more. Is that what it is? Troublemakers ain't troublemakers no more. Let me backtrack because I did Granny. Appreciate this super sticker, Sean, Lavique, Paris, Latasha, and appreciate you for being a member, Kiwana. So once again, I appreciate everybody for pulling up to this demonstration. There my troublemakers go. There they go. There the troublemakers go. There they go. There they go. I see you, Spicy. Mr. Shank, can you please let Miss Parker know that I'm blocked and I can't even join in on her lives? I'll let her know, Shy. I'll let her know. Patricia says, please take those horses down. There go my troublemakers down there. There my troublemakers go. I've been recovering, Shank. Hand surgery. Can I get everybody to throw up some prayer hands for Tower Scales? I see you, Spicy. If we don't get justice for all his victims, we'll never be the same. Oh, the coming now. Please take them horses down. Salute everybody. I appreciate everybody for pulling up. I'm going to leave the chat running and y'all can hang around. I'll see everybody back tomorrow. I got some new information on Malcolm Jamal Warner. So make sure everybody pull up for my Malcolm Jamal Warner demonstration. Salute everybody, and I'll see y'all tomorrow. I'd like to place an order. Yeah. Hey, let me get a chicken box and a half and half. All right, good looking out. Tinted window screaming after law out my mouth. I'm switching lanes from up north to down south. Now everybody trying to figure how I put it down. I took my show on the road straight out of town. Pee-wee is my nigga, so you know I brought some crooks with me. 1998.
They trying to throw the book at me.
Tell me what you see every time you take a look at me. A straight P, I only be where the hookers be. A old head, but still can pull any fly chick. One thing's for sure, you never see me ride a nigga dick. I got a thoroughbred who loves to call me pretty daddy. Through Alabama, getting hit in a pink caddy when I come through. Everybody knows me, the young niggas love me. They call me they OG. Go and do your homework about the shit that I spit. They gon' tell you that that nigga Shank is legit. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. I eat a chicken box before I play a game of spades.
Can I get some
a half and half is sweet tea mixed with lemonade. Some brown liquor with a coke to sharpen up my skills. I switch lanes cause I only fuck with the real. Now she's a winner, so I got to keep her on my team. Plus I'm a real one, so I never ever sell her dreams. You wanna know if I'll quit or if I'll stop? But they say it ain't over till your casket drops. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane. A chicken boxer half and half when I'm switching lanes. When I'm switching lane.